Hi there, this is Erica Marilyn. I'm the founder of Perfect Legal Video, and I am very excited to bring to you today Attorney Nicole Reeves Lavallee. She has a family law firm out of Worcester, and she is absolutely amazing at what she does. And we're very fortunate to have her come on this show once in a while and give us some fantastic information. Today, we're going to be talking about something that a lot of people, I'm sure, wonder about. What are the ramifications for being in contempt in a family law case? So welcome to the show today, Nicole. Thank you so much for joining us.
Thank you. And this topic is very prominent right now. A lot of people are doing the wrong thing and not doing it for the right reasons. And there's ramifications. So you guys need to know about it.
Absolutely. So let's just start off with a simple definition like we usually do. What is the said standard?
So the standard is a contempt is going to be a court order. So you're going to be found in contempt of a court order. So we have to look at, is the order clear and unequivocal? If it says you're going to pay child support of $200 a week due every Friday, that's clear and unequivocal. Versus, hey, you're going to have the child after school. Well, does after school mean 3 o'clock? Does it mean 5 o'clock? Does it mean 7 o'clock? A little gray area. So clear and unequivocal. Is that order clear and concise? The other part of that is your actions willful and wanton? I'm stuck in the car and I know I'm supposed to pick them up at 3 o'clock, but I couldn't get there to 3:30 because there was an accident on the highway and everything was backed up. Clearly not willful and wanton, because your actions are, I tried, but I couldn't make it. Versus, hey, I'm just going to show up a half hour late every single time because I don't give a damn. That's willful and wanton actions.
I mean, and that makes sense because, sometimes the couples are fighting, or the ex-couples are fighting, and they do like to do things to press each other's buttons. And you want to make sure that it's a real situation. I mean, I was just talking about with a friend, we had a terrible snowstorm a few years ago, and everybody was late picking up their kids. There was just nothing people could do. You were waiting, trying to get home for 3 hours, what would normally take 1 hour. And so, yeah, stuff like that happens. But if you're just constantly showing up a half hour, 45 minutes late to drop off, then that's really rude and inconsiderate to the other parent who might have things to do. So who is it that actually judges this, though? Who makes the decision whether someone is being willful and wanton, or it's just a case of things happen?
Well, generally you're going to go in front of the judge, and that judge is going to make the determination. Now, you can say their actions are willful and wanton because you know the words now, but it doesn't matter. It's not matter what you say. It's about whether or not the judge can find it. So only the judge can make that determination. You can argue it, you can state its fact, but at the end of the day, the only person that can make that decision and hold somebody in contempt of court would be the judge.
And that's always an exciting time when they yell, "You're in contempt." Or is that just in the movies?
That's in the movies. What we do here is, I will take it under advisement. Every once in a while, when you've done it 3 or 4 times and the judge knows your MO and knows that you're doing this action willful and wanton, such as, I'm just not going to pay the child support, I'm going to wait till it gets so high, and then she's going to file a contempt, and then the judge will make me pay and whatever. In those particular cases, the judge will say, bailiff, handcuffs, and you'll get locked up. In which case, guess what? She will say, I do find you in contempt of court. That is probably the only time that the judge is going to find you, if and when they're going to lock you up, and you're going to have a purge amount or some kind of expectation before you can get out of jail because you've done something wrong so many times on a repeated basis.
So one would assume that sometimes people have conversations before court. Usually the judge requires it, right? They send you out in the hallway and they try to figure this out for yourselves. What happens if you do settle before court?
You can settle, obviously you can settle before court, outside of court entirely. Like I've got the summons in my hand and I just got served. Oh my God, I need to reach out to my ex and find out what it is he or she wants and how do I make this right. That's the easiest and most cost-effective way to do it, because then it's probably going to be dismissed before anyone even has to go to court and take a day off from work. But obviously, you can also do it that morning of in probation, or even by Zoom probation now. And they will talk to you and they will go over your case and they will say, I think you should do this, this, and this. What about this for settlement? So obviously you can do it by probation, and then we would sign an agreement before then. And most likely you would not even have to go in front of a judge. Or again, you can do it as we're walking into the courtroom and somebody goes, hey, Nicole, can I stop you for a minute? Let me see if this will work. And then you can make an agreement there where we would just tell the clerk, we're running a little behind, we're working on an agreement. And then again, sign an agreement, and then we don't have to go in front of the judge.
And that makes a lot of sense. And one would hope you can settle before, because otherwise the judge is going to make the decision. And usually people don't like that. Usually they like to be able to compromise on their own. But if worse comes to worse, what can you expect if you have to settle this in court?
Again, it's going to be depending on what type of case it is and whether or not you have an attorney, but plan on going to probation, plan on having all of your documentation that supports it one way or another. The hardest part is proving a negative. I paid child support. No, you didn't. Okay, I can't prove that I don't have checks, but the other person can obviously prove that they do have checks. And that's kind of the catch-all situation where we're going, I can't prove that you didn't do this. There's just no proof here. But when you do have proof, make sure you bring that. Make sure you have it available to the court, you have it available to the judge, to opposing counsel, so that we can take a look at it, because sometimes our clients aren't truthful and sometimes the other party isn't truthful. So we need to know who's responsible. And then we also need to tell those clients the ramifications of, hey, if you go in front of the judge and they present this document, that's going to be very hurtful to your case, and maybe we need to settle. So there's a lot of ramifications, a lot of things we can do beforehand. And realistically, every case should settle, and we should not be going in front of a judge on a contempt hearing.
But what if you go through all of that and people are not being reasonable? And you probably see this a lot. There are just couples that are not going to agree. Even if one thing really is the best thing to do, they're not going to agree. So what happens if they are found in contempt? They didn't pay their child support, and it was for nothing more than being spiteful, and they're still not trying to make it right. So now they're in contempt. What happens?
Well, obviously, in court itself, the judge is going to have to listen to the evidence, listen to both party sides, listen to any document or review any documentation and evidence that's presented before them. But again, it depends. If it's multiple times, you can be locked up. You can go to jail. And those are the cases where you're going to have a purge amount. You're going to say that you are in lockdown for 10 to 30 days unless you do this, and you come up with $10,000. And an attorney talked to me the other day about something like this, and she said, yeah, I got a call from this guy that I haven't seen in 20 years. He called me up and he said, I'm not doing so well. I'm in jail. Do you have any money? And she laughed at him. She goes, well, if you haven't talked to me and you don't have any money and you haven't paid your child support, what makes you think you're going to pay me? But guess what? It does happen, and you go through your entire Rolodex, or whatever we want to call it nowadays, and say, who's going to front me some money because I screwed up big time? Obviously, there's other cases where it could be that I'm just losing my kids, or I'm losing parenting time. Those are just as harsh on the person that is the person found in contempt. So you've got to look at those ramifications, which is why, again, talk to your attorney about settling, about coming up with some agreement. It may not be the one you want, but if it's something, it's better than lockup, and it's better than losing your children.
And that's true. And that has happened to me as well. And I was really surprised. I got a call from someone that was an ex-manager of mine from like 8 years ago that I hadn't talked to in a long time. And I'm like, oh my God, hey, how you doing? He's like, not so great. I'm sitting in jail. you have any money? And I'm like, what? Like, no. And I was single, no kids, had no idea about any of this stuff at the time. And I was like, yeah, same thing your friend said. I do not think I'm giving someone money who's not paying their child support. It's crazy. So we've touched on a couple of reasons people can be in contempt, but I know there's a lot more. So if you could just list out some of those reasons people could be in contempt, what are all the things that people are doing wrong? And even now, and I know, like, you can even make it in relation to what's happening now, because that's what we were chatting about before we got on today, and how lots of people are not doing the right thing coming out of this pandemic.
Yeah, I am obviously the most important and the most common is going to be child support, parenting time, or not giving parenting time. Those are the ones that happen pretty much on a regular basis. The other ones are going to be something like health insurance. Like, I terminated yours or the child's health insurance, didn't bother to tell you, either lost my job or quit, and not really interested in covering you anymore. Those are kind of a prominent thing. Sometimes it's related to college education. So there's an order that says you're both going to split the college education. One person says, no, I'm not doing that. So again, financial issues. But we also have things like we had to sell the house. Upon graduation of the youngest child, we're going to sell the marital home, and we're going to hire a broker, and it's got to be listed, within a week of graduation. Perfectly reasonable given the time of year, right? Guess what? In a month from now, how many calls do you think I'm going to get that says, hey, my ex is supposed to sell the house and they haven't done it. What's my options? The option is to send out a demand, find out if they're going to. If they're not going to list the house, then we file a contempt on that and we get a court order forcing them to sell the property. Sometimes it's returning personal property. That's probably the hardest one to win on in any way, shape, or form, because it's never clear as to what that personal property is. A bedroom set. Okay, what's that include? Is that a bedroom set for the bed and the bureaus and the dressers? Is that the mirrors? Is that the end tables? What does that look like? Everybody's different. So again, when you have that language, you got to be clear, or they're not going to be in contempt because the order is not clear and unequivocal. The bedroom set in the master bedroom that consists of the dresser, the bed, the end tables, the two bureaus, the mirrors, the side table, whatever it is, the ottoman, that is oak color. Now I have something to hang my hat on. So now that I have that clear and unequivocal order, the other part of that is, oh, but you forgot to mention the condition of it. It happened to break when I was moving. It's so sad. Here's the broken pieces. So again, we have that where you have to define the items, and you also have to define the current condition of them. And they have to be in a reasonable current condition, normal wear and tear excluded. So again, we run into a lot of problems with personal property issues that are almost next to impossible to address. Obviously, the other parts that I'm doing right now is a quadro. We're supposed to be dividing up a retirement account. The other party won't sign the documentation, won't give us the statement. We can't do the quadro. Why do I have to file a contempt on something silly like this? You have an order, you say you're going to cooperate, you haven't cooperated, and yet here I am doing it. So that's a common one that's been coming up more recent. And then I think lastly is going to be your alimony. Obligations of you're supposed to be paying alimony, you're not paying alimony. You're supposed to be paying this credit card, you're not paying this credit card. So liabilities, who's responsible for paying them? Are they paying them? Are they paying them on time? Are they paying the minimum balances, or are they paying a set number that they're supposed to pay? Again, we need to look at that order and say, are the parties splitting the minimum balance, or is the party supposed to be paying all of it within 60 days? So what does that look like, and why aren't they paying it?
That is so funny. You mentioned that about the personal property. I mean, you've mentioned a lot of great things. That happened to me once too. I had rented an office from someone, and they said, you can have all the furniture in here. And then she didn't give me the office. And I'm like, well, at least give me the furniture that you said I could have. And went all the way down, rented a U-Haul, went to pick it up. It was completely different furniture, and it was crappy. So it's definitely interesting. And I had won that in small claims court. But there you go. Don't use an attorney and look what happens.
Sometimes even having an attorney causes that same problem. But at the end of the day, it's one of those things that our job is to protect you as much as we can. So the more details you give me, the better off I am.
And this is all really great information, but and I would say that, it is so important to have an attorney when there are issues of contempt, because things can go wrong. I mean, there's a lot of different reasons, and you want to make sure that you have the best chance possible to settle it out of court and, try to remain as friendly as you can. But if you have to go into court, you have someone that has your back, does this every single day, and knows what the laws are, and most importantly, what the changes are and what's happening in today's current environment. So I absolutely would recommend Nicole Reeves Lavallee, because she's amazing at this. And, I know a lot of her clients, and they've given wonderful testimonials about the great work you've done.
Thank you so much.
You're welcome. And I want to thank you so much for coming on today. This has been a wonderful show. I loved all the information and the interesting stories that go behind contempt. It's not a laughing matter, and it's not funny. It's just, I smile sometimes because I just find it amusing to see what people are trying to get away with now. And I'm sure you do occasionally.
They try to get away with a lot. And at the end of the day, the judge has seen it all. You have to understand that they've been on the bench for a long time. Prior to that, they were attorneys. They were probably trying to finagle exactly what your client is getting away with or trying to get away with. So don't think you're trying to pull their wool over their eyes. You're not. They know it, and they're going to catch you.
Well, and you heard it here first, folks. Thank you so much for coming on today. Thank you, audience, for listening. I hope you have a wonderful day and a weekend, depending on when you're watching this. And we will see you again soon. Bye now.